Good morning. I'm just waiting to see that the live stream has started. Okay, it's been confirmed. Good afternoon. I am Judge Stanley, and I want to welcome you all to the Office of Tax Appeals. The hearing today is for appeal of Hambardzumyan. I hope I'm pronouncing that right. It's being live streamed and will be posted on OTA's YouTube channel. So don't share anything on your screens. Mr. Demirchayan, I guess you're not showing a screen, so that's not a risk of showing it publicly. But please silence your microphone when you're not speaking and remember to turn it back on when you are speaking. A stenographer, Ms. Alonso, is present and she's reporting this hearing verbatim. To ensure we have an accurate record, we're going to ask that each person speaks one at a time and avoids speaking over one another. Also speak clearly and loudly, and when needed, Ms. Alonso may interject to ensure that she gets the proper transcription. After the hearing, Ms. Alonso will produce the official hearing transcript, which will be available on the Office of Tax Appeals website. Are we ready to go on the record, Ms. Alonso? Okay, I got a thumbs up from her. So we're going on the record in appeal of Hambardzumyan, Office of Tax Appeals, case number 230813957. The date is March 19th, 2025, and the time is 3:28 p.m. This hearing is being held electronically with the agreement of the parties. Once again, I am Judge Stanley. I will be the lead for purposes of conducting this hearing. My co-panelists, Judge Aldrich and Judge Ralston, and I are equal participants in deliberating and determining the outcome of this appeal. As a reminder, the Office of Tax Appeals is not a court. The Office of Tax Appeals is an independent appeals body, which is staffed by its own subject matter experts, and it is independent of CDTFA or any other tax agency. I'm going to ask the parties to introduce themselves and who they represent, starting with appellant. Mr. Demirchayan, can you unmute your microphone and introduce yourself, please?
Yeah. Name is Grigor Demirchayan. I am representing David Hambardzumyan.
Okay. So it's Demirchayan, right?
Yes.
Sorry. Okay. And then CDTFA?
Jennifer Berry, representing the Department of Tax and Fee Administration.
Harry Huxall from the department's legal division.
Jason Parker, Chief of Headquarters Operations Bureau with CDTFA.
And just to confirm, Ms. Berry, you're the hearing representative for this hearing?
Yes, I am one of the attorneys with the legal division.
Okay, thank you. Okay, so to start with, as stated in the minutes and orders, the issue to be decided in the appeal is whether, well, there are two issues. First, whether appellant has established that adjustments to the audited taxable sales are warranted. And Mr. Demirchayan, I'm going to also list what I think are the three major issues that appellant has raised in this case. And that is, were the observation tests in March 2019 representative of appellant's business, which closed its seller's permit effective January 3rd, 2019? And has appellant established that the operating hours and business days were miscalculated in the audit? And has appellant established that the average sales price per customer used by CDTFA was incorrect? And the second issue is whether the negligence penalty was properly imposed. Are these what you understand the issues to be, Mr. Demirchayan? You need to unmute.
Yes, Your Honor, I understand.
Okay, and Miss Berry, is that what the department understands the issues to be?
Yes.
Okay. Appellants submitted exhibits 1 through 9, and at the pre-hearing conference, CDTFA did not object to the admissibility of these exhibits, so they are admitted into evidence at this time. And the Franchise Tax Board submitted exhibits A through Q. Appellant did not object to the admissibility of these exhibits, and they are also admitted into evidence. Oh, did I say Franchise Tax Board? Oh, I did. I'm sorry. Let me correct that. The CDTFA submitted exhibits A through Q, not the Franchise Tax Board. But they are still admitted into evidence without objection. Neither party intends to call a witness to testify today, so I won't need to swear anybody in. Mr. Demirchian, you requested 60 minutes for your presentation. You can proceed when ready, and don't forget to turn on your microphone.
Good afternoon, everybody. Good afternoon, Your Honor. And I'm representing Mr. David Hambardzumyan. And based on the documents, the department found Mr. David Hambardzumyan liable for more than $100,000 sales tax liabilities. And we do not agree with that. And I will present some facts that will confirm our stance. Now, just a little bit background of Mr. Hambardzumyan. They moved to US from Armenia in 2005 with his family. And the life was very tough in Armenia. Corrupted government, no human rights, no freedom. But the justice system was very simple. Rich was always right, and the poor always guilty, as the money dictated the justice. And if the government goes after you, most likely you will be in prison. So their dream was to come to America. We have very little corruption here, and everybody has a right to defend themselves. Although if you are rich, you can hire a top lawyer, and if you are not rich, you can hire a retired accountant. But other than that, as Abraham Lincoln said, nobody is above the law. So the question and the issue I have is whether Mr. David Hambardzumyan is liable for the sales tax imposed on him by the department. To answer these questions, Your Honor, I need to see whether Mr. David Hambardzumyan conducted any business activities after January 3, 2019, because the department calculated all these tax liabilities based on the events occurring after January 3, 2019. So I will present the fact, and the fact is that Mr. David Hambardzumyan started the business on February 4, 2018. Mr. David Hambardzumyan closed the business on January 3, 2019. We can see Mr. Hambardzumyan's declaration on page 3. He declared under penalty of perjury that he stopped the business. And the perjury, if you lie, you go to prison. We also have on page 95, lines 7 through 8, it states that the department closed petitioner's seller's permit effective January 3, 2019, meaning they agree that the petitioner stopped the business. On March 19, March 25, March 21, the department's statewide compliance and outreach program scope conducted outside observations during which they noticed about 20 customers during 1 hour entering the business premises, meaning every 3 minutes, 1 customer. The question I have, did they see David Hambardzumyan at the business premises conducting business? The answer is no. On April 12, 2019, department conducted a visit to the business premises. The question I have, did they see Mr. David Hambardzumyan conducting a business? The answer is no. On May 8, department conducted another visit to the business premises. The question is again, did they see Mr. David Hambardzumyan conducting a business? Answer is no. The scope conducted outside observations and all other visits show that the department doesn't have any single evidence showing that Mr. Hambardzumyan conducted any business after January 3, 2019. On the contrary, they presented facts, the department presented facts that others were conducting business, and it's written on page 95 of the binder, lines 17 through 24. Based on this, it looks like that the department ignores all the facts. And I have to say that intentionally they misrepresent them to misrepresent the facts to justify their conclusions. Why do I say this? On page 116, lines 15 through 20, the department states that they have relied on leadmap.com and not on allbut.com pictures to calculate the hours, operating hours of the business. So when I ask the printout of the leadmap.com, the note on that page, note 12, it says no printout of website, but they don't have any questions because other websites have the same posted hours. I mean, at the first place, they say that they didn't use our other websites and they based their calculations on the hours taken from the leadmap.com, and then they are saying we don't have the leadmap.com outprint, but we used the other websites. And the other websites I sent them, Your Honor, and it's a printout from Allbad. It is on page 227 and on page 93. The outprint was the dates of the picture, and the dates are August 18, 22 and September 18, 22. These are, the business was closed in 2019. After 3 years, the website still shows that the business is operating from 10 to 10, and it says it's now open. So the website is misleading. I just don't understand how you can make liable a person of hundreds of thousands of dollars based on the misleading websites. Also, Your Honor, on page 125, lines 7 through 9, they admitted that Mr. Hambardzumyan was not identified at the locations during the observation days. Now the department admits that they didn't see Mr. Hambardzumyan conducting business. But then the department saw other people conducting business, which is stated on page 95 on lines 17 through 24. But they say, no, these people are not liable. Mr. Hambardzumyan is liable. I mean, you see other people doing business, but you are still charging Mr. Hambardzumyan for not doing business. This is like, Your Honor, I just want to compare that. It's like somebody steals my car, goes have an accident, and kills somebody and runs away. The police comes and says, oh, who is the owner? Oh, he is the owner. Charge him. Obviously, they saw that other people are conducting business, and they ignore it. I don't know why. On its brief dated November 30th, 2023, the department, in the footnote number 2, states, the sworn statement also asserts, this is the declaration of Mr. David Hambardzumyan. The sworn statement also asserts that he did not engage in any business transactions mentioned one second, Your Honor. Statement also asserts that he did not engage in any business transactions mentioned in this case. However, this statement is contradictory to appellant's concession that he owned and operated business through January 3, 2019. Your Honor, the department took Mr. Hambardzumyan's declaration out of context, used only one part of it, and blames him for contradicting himself. The full declaration says, on January 3, 2019, I stopped my business activities, and since then, and since that date, I have not conducted any business activities. And I don't know why the department is doing this. Just misrepresenting the facts. per department, the markup costs were 66.67%, and this is on page 97, lines 1 through 3. And the department found it's low for petitioner's type of business based on its experience. On pages 133 to 134, the department brings an exhibit I, which shows that a marijuana club operates, and based on their exhibit, the markup percentage is 0.664, meaning 66.4% lower than the Mr. Hambardzumyan's markup. So on one hand, they are saying that Mr. Hambardzumyan's markup is low, but on the exhibit that they present, it's even lower than Mr. Hambardzumyan's markup. Numbers. On May 8, oh, I need to see. On December 31, 2019, department states, and it's on page 96, lines 16 through 17, with Ms. Hambardzumyan, and the department states that she told them the business was closed around May 2019. On page 70, I have the Ms. Hambardzumyan's declaration, in which she states that she didn't say anything like that to the department, and this is written declared under penalty of perjury, Your Honor. So again, the department, what I want to state, Your Honor, didn't present any single evidence that will show that Mr. Hambardzumyan was conducting business activities. On the contrary, other people were conducting business activities, but they just don't want to admit that. So based on all these facts, Your Honor, Mr. David Hambardzumyan did not conduct any business activities after January 3, 2019. And there is no single fact to prove that he did. I'm all done, Your Honor.
Thank you, Mr. Demirchian. Judge Aldrich, do you have any questions for appellant's representative?
Thank you, but I do not.
And Judge Ralston, do you have any questions?
Not at this time, thank you.
Okay, I just have one, Mr. Demirchian. You referred to pages 93 and 227 of the exhibit binder. 93 and 227. That is the printouts from, I think it was Albud. I thought you said that there were dates that these were taken from, but the only dates I see on them is the date that they were printed. Did you have a date? Mr. Demerchian, your microphone is not on if you're talking.
Oh, I'm sorry. Your Honor, yeah, on page 93, on the top of the page, there is a print, small print, showing 8/18/22. And on page 227, it says 9/18/22.
I see 9/18/24 on page 227.
Oh, could be 24. I'm sorry, Your Honor.
Okay. Okay, so that appears to be the date that this was pulled off the internet.
Correct.
Okay, all right, thank you. That's the only question I had. So you can go ahead and remute if you'd like. And I'll turn to Miss Berry. The department requested 20 minutes, so you may proceed when ready.
Yep. Judge Stanley, can I interrupt for just a second?
Hi.
Can we go off the record for just 2 seconds? I need to plug in my machine.
Okay, we're gonna take a short recess. Mr. Huxall and Miss Berry, can you turn your cameras off temporarily? Okay, it looks like our stenographer and got the machine together, so we're ready to continue.
Thank you.
Mr. Huxall and Miss Berry. Okay, there they are. Okay, Miss Berry, now you can proceed when ready.
Okay, just one moment. Oh, am I still on mute? Yes, sorry. Okay. Appellant operated a cannabis dispensary in North Hollywood, California, under the name of the Fave Smoke Shop. The business sold recreational and medicinal cannabis and related products. The department initially visited appellant's business on April 18th, 2018, at which time the cannabis dispensary was found operating in the location and displaying signs with appellant's business name. Another field visit to the business was made on August 8th, 2018. During that visit, the department spoke with an employee who refused to provide her name or the name of the business owner. Following the initial visit to the appellant's business, a seller's permit was issued to appellant with a commencement date of February 4th, 2018. These events are detailed in Exhibit L. Appellant did not notify the department of any change of ownership or close of the business until April 3rd, 2019, when appellant submitted an online request to close his seller's permit effective December 29th, 2018. This request is included as Exhibit P. Following discussions with appellant's representative, the department ultimately closed out appellant's seller's permit effective January 3rd, 2019, despite appellant having no documentation to substantiate the assertion that the business was closed on that date, and there being evidence that the business continued to operate thereafter. The liability period at issue here only includes the period between February 4th, 2018 and January 3, 2019. No liability has been assessed for any period beyond January 3rd, 2019. It is therefore undisputed that appellant was the owner of the business during that period at issue, February 4th, 2018 through January 3rd, 2019. The department conducted 2 observation tests of the business, one on March 19th, 2019, and a second one on March 21st, 2019. The department also attempted to conduct a 3rd observation test on March 25th, 2019, but the business was not open that day. The records for these observation test dates may be found in Exhibit I, pages 20 to 22, and page 52. Appellant did not first contact the department about the purported closure of the business until after the dates of these observation tests. Following the observation test dates, the department mailed appellant an audit engagement letter on May 6, 2019 to his business address, requesting his books and records for the liability period. The department also delivered the letter to the business location on May 8th, 2019. The audit engagement letter may be found as Exhibit H. Appellant only provided his federal income tax returns for 2018 and incomplete daily sales summaries for 2018. He did not provide any additional documentation. Though the department made repeated requests beginning on May 6, 2019 for supporting documentations to facilitate the audit, on March 6, 2020, appellant's representative informed the department that appellant did not have any additional documentation to provide. A record of the contacts between the department and appellant's representatives during this time period may be found in Exhibits J, L, and M. As set forth in Revenue and Taxation Code 6481, the department used the information available to it to determine appellant's liability. Specifically, when the department is unable to make a determination based on a direct examination of a taxpayer's records, as is the case here, the department may employ an indirect audit method to establish a taxpayer's liability. In this case, in addition to the information contained in appellant's sales and use tax returns and his 2018 personal federal income tax return and the incomplete daily sales reports for 2018, in determining appellant's sales during the liability period, the department relied upon information obtained from the 2 observation test dates, March 19th, 2019 and March 21, 2019, and publicly available information regarding appellant's business hours that was posted on the internet. Appellant objects to the department's reliance on the observation test because he asserts that he was not the owner of the business during the dates the observation test was conducted. However, the liability established by the department is reasonable and reliable for several reasons. First, as noted, the appellant did not inform the department that the business was closed or under different ownership until April 3rd, 2019, which was after the observation test dates. Thus, the department had no reason to believe that it was not observing appellant's business during the 2 observation test dates. Second, during the observation test dates, signs with the same business name were posted on the door of this business location. Additionally, the business was conducting the same business activities and was operating in the same location as appellant's business. Here again, the evidence indicates that appellant continued to operate the business beyond the observation test dates. And there is no evidence that the business that the department observed on those 2 test dates was not appellant's business. Although appellant has asserted that the department should have verified he was present during the observation test dates, appellant's presence or lack thereof at the business on the dates of the observation test is not indicative of the sales made on those days or of whether he was the owner of the business at the time, as there are a variety of reasons why an owner may not be physically present at a business during operating hours. Finally, even if the business was no longer owned by appellant on the dates the observation test occurred, as appellant has asserted, the department is authorized by Revenue and Taxation Code Section 6481 to utilize any information that comes into its possession to verify the accuracy of appellant sales and use tax returns and to make a determination of any amounts owed. Since the department had to use an indirect audit method due to appellant's inadequate records, The department was authorized to use a variety of audit techniques to estimate appellant's taxable sales for the liability period, including comparing appellant's sales to the sales made by similar businesses. In this case, even if appellant no longer owned the business during the observation test dates as he asserts, the department still utilized an observation test of the closest possible comparable business to appellant's business, one that was an immediate successor to his business, to make the to make its determination. Absent complete books and records for the liability period, the results of the observation test are information that the department is justified in relying upon to make its determination in this case. Thus, it's the department's position that at the time of the observation test, the business observed was appellant's business, and even if it was not as appellant asserts, the sales observed were representative of appellant's business. The determination, therefore, was reasonable and rational. Additionally, with respect to the calculation of sales based on the department's observation, the department attributed purchases to only 2 out of every 3 persons entering the business during the observation test dates based on appellant's assertion that vendors, friends, and family may have entered the business and not made any purchases. Please see Exhibit I, page 29, regarding this adjustment. Following the April 7th, 2022 Appeals Bureau decision on June 7th, 2022, the department reduced its determination of appellant's unreported taxable sales from $1,971,871 to $1,266,481. This adjustment was made as a result of a reduction in the number of customers observed by 30% to account for the time of day during which the observation tests were conducted, and by removing 2 days of business operations during the fourth quarter of 2018 to account for dates on which appellant asserts that the business was closed. The adjustments ordered in the April 7th, 2022 Appeals Bureau decision may be found at Exhibit A, and a record of the adjustments that were made may be found in Exhibit I, pages 47 through 73 and 76 through 79. We also reiterate that though the observation test dates occurred after January 3rd, 2019, the department has not assessed any liability determination beyond January 3rd, 2019, and there is no dispute as to ownership during the liability period. As to the average sales amount utilized, the department determined that $41.95 was the average purchase amount per customer during the liability period based on its experience auditing similar businesses. This determination is detailed in Exhibit I, page 55. As set forth in appeal of TFCG Incorporated and Todd versus McColgan, which is 89 Cal App 2nd 509, and Riley Bees Incorporated versus the State Board of Equalization, citation is 61 Cal App 3rd 610. Where the department's determination is reasonable, as it is here, the burden of proof shifts to appellant. And as set forth in Regulation 3219, the burden of proof is upon appellant to prove all issues of fact by a preponderance of the evidence. Appellant must establish by documentation or other evidence that the circumstances he's asserted are more likely than not to be correct. Further, appeal of TFCG Incorporated makes clear that unsupported assertions are not sufficient to satisfy a taxpayer's burden of proof. Absent additional records to corroborate appellant's reported taxable sales during the liability period, no additional adjustments are warranted. Though appellant provided his personal bank statements for January 3rd, 2018 through June 20th, 2019, which are set forth in appellant's exhibits 4 and 8, these bank statements do not appear to establish a record of appellant's sales during the liability period or support any adjustments, though they do include some very large cash deposits. The burden is on appellant to provide adequate books and records to substantiate his reported taxable sales for the liability period, and he has not done so. The determination here was reasonable and rational, and appellant has not established any basis for further adjustments to the liability. With regard to the negligence penalty, we do know the department also asserted the 10% negligence penalty against appellant in the audit. Although this is appellant's first audit, appellant has failed to provide adequate books and records to substantiate his reported taxable sales for the liability period. Additionally, the understatement following the adjustments made on June 7th, 2022 is still substantial, totaling $1,266,481 and representing an error rate of 674.92% over a period of less than 1 full year. The lack of adequate books and records and the severe understatement, even after adjustments in appellant's favor were made, indicate that appellant did not have a good faith and reasonable belief that his record keeping and reporting practices were sufficient for sales and use tax purposes. Based on the foregoing, the measure established upon audit was reasonable and based upon the best available evidence. Appellant has not met his burden in establishing any additional adjustments are warranted, and accordingly, this appeal should be denied. Thank you.
Thank you, Ms. Berry. Judge Aldridge, do you have any questions for CDTFA?
Sure. My understanding is that the initial scope visits happened in 2018, and at that time, appellant did not have a seller's permit, or was it a different kind of permit that was expected?
At that time, appellant did not hold a seller's permit or any other permit.
And then, is there anything in the record that shows what the permit process was for appellant? Eventually one was obtained, and so how that process came to.
I know that appellant, maybe through his representative, did apply for a seller's permit following the first visit in April of 2018. And I believe that was done or processed around the end of May 2018. And then that was the only interaction there.
And I was also wondering what, if any, publications were provided to the appellant in that seller's permit process?
I do not have that information currently available, but I can provide follow-up with that information unless Jason may have that on hand.
Hi, this is Jason Parker. I don't see in our notes in our system the publications that were provided, but we can look into that information and provide it at a later time. I know that we provide links to a lot of the publications when taxpayers register online nowadays.
Okay, thank you. This question is for appellant's representative.
Yes.
So my understanding based off the hearing binder is that the reason that appellant didn't have records to provide was due to some sort of police activity. Is that correct?
Yes, Your Honor.
According to appellant's position.
Yes, we have explained it. We have explained it to the department. The police entered and confiscated everything. The computers, the books, everything. And we asked department's help. Just maybe they can help us to go to the police department and get all the confiscated equipment and records. They said, oh, we cannot do that.
Okay,
and,
so
they are not. Yes.
1 second. So typically when a seizure happens, there is some sort of receipt provided of what's actually taken. Does appellant have a copy of such a receipt or something similar?
No receipts, nothing. They just confiscated everything and they took it away. Because the Mr. Hambardzumyan applied. Yes,
so
yes, Your Honor.
There's nothing that documented the interaction between the police department and appellant showing the exchange, showing that like what items, if any, were taken?
No, Your Honor, there is nothing.
Okay. Thank you.
Because
did you want to add something?
Yes, because the Mr. Hambardzumyan applied for the special license to sell marijuana, but he was waiting to get that license. So when the police entered, they said it's illegal business, so they took everything and they went away.
Okay. And so if given the opportunity, it wouldn't be something that appellant were able to provide to substantiate the claim that the police department took his records. You just don't have it. Is that
Yeah, we don't have it.
okay? All right, thank you. No further questions, Judge Stanley?
Judge Ralston, do you have any questions for Ms. Berry?
No questions, thank you.
Okay, and I don't have additional questions either, so I will turn it back to you, Mr. Demirchan. You can, you have 5 minutes to make a closing statement.
Okay, Your Honor, I just want to refer on pages 63 and 67, part 2, number 26. And it's the tax return, Mr. Hambardzumyan's tax return for the years of 2018 and 2019. It's a sole proprietorship. And 26 shows, it says wages, and you can see 0 there. This means that Mr. Hambardzumyan, it was a one-man operation. He didn't have any employees, meaning if he is there, the business is open and operating. If he is not there, the business is closed. So once again, when the department went and saw other people conducting business, it wasn't Mr. Hambardzumyan, and there is no single evidence. And when the department is saying that they took, even if the Mr. Hambardzumyan wasn't there, they did their calculations based on other businesses. I mean, Your Honor, I'm having a hard time to understand. There are so many similar businesses that one business is doing millions of dollars, the other business is just going out of business within a year. Let's say a restaurant in Beverly Hills makes millions. Another restaurant next to it opens and gets out of the business in 1 year. How you can take those numbers from the other restaurant and charge the other restaurant for sales tax or for some other tax? I just don't understand that. And the bank statements show that Mr. David Hambardzumyan didn't earn that much money. Bank statements are almost the same, whatever the tax returns show. And those tax returns are serious documents, Your Honor. You don't want to mess with IRS. How is it possible? Per their calculation, that first they said that Mr. Hambardzumyan owes about $400-something thousand. If the sales tax takes 10%, let's say, it means that Mr. Hambardzumyan made $4 million of sale. And where is the money? The bank statements doesn't show it. The lifestyle of Mr. Hambardzumyan, who still rents apartment and lives with his mother, doesn't have that money. And where is the money? The tax return shows that he didn't make that much money. The bank statement doesn't show that. But the department goes and calculates the sales tax based on other businesses. How is it fair to do that? Again, Your Honor, my observations show that the department does not care about the. I'm very sorry, but they does not care about the truth. I understand that the lawyers should act with commitment and dedication to the interest of the client, but it must be honest, Your Honor. I mean, it must be honest. With this, they are just killing the taxpayer's future. the all evidence shows that he didn't make that much money. Now he has this hundreds of thousands of dollars penalty on him, and he is not able to do it. Yeah, this will just kill his future. It's just unjust from the side of the department. I'm done, Your Honor.
Okay, this is Judge Stanley again. Thank you, Mr. Demirchian. Judge Aldrich, do you have any final questions for either party?
I do not, thank you.
Judge Ralston?
No questions.
I do have a question for you, Mr. Demirchian. You said that Mr. Hambardzumyan was the sole employee, so that he didn't have any employees, I should say. And so if there was somebody else in there, it wasn't related to him and his business. What happened on January 3rd, 2019? Did he sell the business?
He just walked away.
Did he?
He was robbed couple of times. The police confiscated everything, and he wasn't able to get that special license to sell marijuana. So he was losing money, and he just walked away.
So did he lock the business when he walked away? I'm not understanding how other people could get in there if he had product in there and his sign on the door.
There was no product, Your Honor. Everything was robbed. Everything was gone.
Okay. All right. Thank you. So the record in appeal of Hambardzumyan is now closed. I want to thank everybody for joining us and participating today. The panel will meet and deliberate and decide the appeal, and we will issue a written opinion within 100 days. So today's hearing and appeal of Hambardzumyan is now concluded, and the Office of Tax Appeals will reconvene for additional hearings tomorrow, March 20th at 9:30 a.m. Thank you all.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you.